Hi, everyone. Welcome to today's new format. My name is Kirti Kanchinadam. I'm at the California Pan-Ethnic Health Network, and I'm going to be facilitating today's call. We are here today as our Having Our Say coalition, but we've invited some guests and others to join us on today's call, which we're doing in a webinar format. So we are recording today's webinar for our partners to refer back to and to share with your networks. So we will share today's slides and recording with you after the call. Today's webinar is going to be a training on public charge. I think folks know that there is a lot happening around new proposed regulations around the term public charge. There have been many training opportunities and many great coalitions of advocates working on these issues. We wanted to have a chance to put together a training for the communities that we work with that you can refer to and share with folks. So today's training will cover the status of public charge policy, get a little bit into the what's actually proposed, who's actually impacted, and how is the policy changing. We'll also talk about strategies to work with community members. What are some key messages to share with community and consumers around an issue that's really concerning for many families. And finally, we'll talk about how we can fight back, particularly through the strategy of submitting public comments. So we'll talk a little bit about what are public comments, who can submit them, and how do you walk through the process of how to submit them. So for those of you that are just joining us, this is a recorded webinar, and we still want to make sure that we can have an interactive conversation. So please do use the chat feature or the questions feature on your GoToWebinar panel. And type in any questions or comments that you have for myself or today's speaker. You can type your comments and questions in at any time during the webinar, and we will be tracking them. We will have time at the end of our presentation today to go through some of those questions. So we hope to really engage with all of you today. And the bulk of today's webinar will be a presentation. We're really excited to have Eduardo Ramirez Castro from the California Rural Legal Assistance Foundation leading today's training. Maybe we can go to the next slide. Thank you. Eduardo is the UC Presidential Public Service Fellow at the California Rural Legal Assistance Foundation, CRLAF. Which is a long-standing, privately funded rural justice center based in Fresno, really focusing and working with farm workers and low-wage laborer communities. I've really been really honored to work with Eduardo in many different formats. He has conducted trainings on public charge across the Central Valley, working with a diverse audience, working closely with community members and promotoras and healthcare workers, healthcare enrollers, advocates, and allies. So I think that the perspective he brings to this issue is really helpful and relevant to all of the communities that we work with as well. And I'm really grateful that he took some time out of his day today to do this presentation for all of us. So again, I just want to remind folks to please interact with us, use the question feature, send me a note or some questions, and we will turn it over to Eduardo now to introduce himself and start the presentation.
Thank you, Kirti. Good morning, everyone. I'm Eduardo, and thank you for joining us today. Next slide, please. So as Kirti mentioned, I'm from California Rural Legal Assistance Foundation here at the Fresno office, and I am very glad you are able to join us today. Next slide, please. So just a few disclaimers. So as Kirti was mentioning, there are a lot of things happening very fast. Executive orders, policies, guidance, updates, administrative rules, etc., going on. A lot of them having to do, with different areas of immigration and immigration enforcement or administrative procedures. So we want to start off with some disclaimers. So there are a lot of things changing really fast. There are a lot of unknowns. And right now we're sharing with you information that we have and that we understand at this time. This presentation is general information and it's not legal advice. If you or your organization has some case-specific questions, we advise you to consult with an attorney who can advise your organization. Also, for case-specific inquiries, refer clients to trusted legal service providers. For example, an experienced immigration attorney or Department of Justice Office of Legal Access Program accredited representative. And later in the presentation, we'll share some resources where you can find access to these service providers. Next slide, please. So then we're going to be discussing what is the status of the public charge doctrine right now. And then we're going to move on to what are some of the proposed changes to it. Next slide, please. So I invite you to approach this training this way. In order for an individual to get a green card, right, or to have permission to enter the country lawfully, there are a lot of requirements they have to satisfy, a lot of them. One of those requirements generally is that they need to overcome what's called the public charge test. And today we're going to be talking about that specific requirement, okay? So the public charge is a person depending on the government for financial and material support. And really what the public charge test is concerned at, it's looking at the likelihood that a person will become a public charge in the future. So this assessment happens when an individual applies to enter the United States through a visa, or when an individual applies to become a lawful permanent resident. And lawful permanent resident is a green card holder. The public charge test does not apply when an individual renews his or her green card, and it does not apply when an individual wants to apply for US citizenship. If the immigrant is likely to become a public charge, if the USCIS officer makes his determination, the immigrant can be denied his green card application or his application to enter lawfully into the United States. Next slide, please. So I told you that the public charge test is one requirement that generally immigrants have to overcome in order to get a green card or to get permission to enter the United States lawfully. But there are a lot of categories of immigrants who are exempt from the public charge requirement. Some of these immigrants include most lawful permanent residents. And I say most lawful permanent residents because in some situations where the public charge test may apply to a lawful permanent resident is when the individual leaves the country for over 6 months and then re-enters again. But in general, most lawful permanent residents are not subject to the public charge test. Refugees and asylees, another category of immigrants who are not subject to the public charge test. Survivors of trafficking and other serious crimes. These involve applicants and holders of T visa trafficking visa benefits for like labor or sex trafficking, and also U visa applicants and recipients. And U visas are typically benefits available to survivors of certain crimes. Self-petitioners under VAWA, the Violence Against Women Act, are also exempt. Special immigrant juveniles as well, and US citizens. Next slide, please. Okay, so this is the test, the public charge test, and we'll discuss it a little bit more on the next slides. So USCIS defines public charge as an individual who is likely to become primarily dependent on the government for subsistence, as demonstrated by the receipt of public cash assistance for income maintenance, or institutionalized care, long-term care at the government's expense. Whether a person is likely to become a public charge is based on all of the facts relevant to their ability to support themselves, which means that immigration agents must consider the totality of the circumstances when adjudicating an applicant's case. Next slide, please. So this is an explanation of the public charge test in a little bit more detail. And I take this opportunity to mention to you that this is the public charge test, whether the individual is applying for a benefit in the United States or the individual is applying for a benefit in their country of origin. However, if the individual is doing their processing in their country of origin, also known as consular processing, they have been applying more scrutiny to the review of some of these relevant factors and to the affidavit of support. So before we move on to this presentation, I just want to preface it by saying that generally, an individual can get an immigration benefit in the United States or outside of the United States. The examples that I'm going to give you right now are of a person who's going to be applying for and receiving a benefit in the United States. If an individual has to receive their benefit outside of the United States, then we strongly urge them to consult with an experienced practitioner who can evaluate their case. So under the current policy, only two types of public benefits are used by the applicant can be considered. For example, if I'm applying for a green card, the immigration officer can review my history of public benefits use, but they can only consider my use of cash assistance for income maintenance, such as SSI, temporary assistance for needy families, also known as CalWorks in California, and also any state and local programs that are equivalent to the aforementioned. Moreover, the officer can also review my history of institutionalized long-term care at government's expense. They can review to see if I have ever been in a nursing home or a mental health institution. These are the only two kinds of benefits that are relevant for a public charge determination. So what does this mean? If I receive benefits, for example, like Medi-Cal or food stamps, these kinds of benefits, even though they're public benefits, they are not cash assistance, nor are they long-term institutionalized care at government expense. So those benefits would be irrelevant in my case. And after the immigration officer reviews my past use of public benefits like cash assistance or long-term care, they also have to keep going. And they also have to review all the other factors relevant in my case, which are my age, health, family status, assets, resources, financial status, and education and skills. And in many cases, for example, like in family petitions or in some employment-based cases, there's another requirement added on there, which is any affidavit of support. And if this would be a family petition case or an employment-based case, then the officer would also have to review any affidavit of support that I submit. And it is only after the officer reviews all of the factors in this slide that they can come up with the conclusion of whether I am likely to become primarily dependent on the government for material and financial support. Okay. Next slide, please. So in very general terms, prior to the October 10th announcement of the proposed rule, advocates and service providers, were able to confidently tell their clients that, the receipt of a lot of cash benefit, of a lot of public benefits that are not cash assistance or long-term institutionalized care will have no bearing on their immigration candidacy in the future. But we have a proposal to change the definition of public charge and to essentially make it harder for immigrants to overcome and satisfy that particular requirement. On October 10th, the Department of Homeland Security published a proposed rule, and this proposal changes the definition of public charge to apply to anyone who uses or receives one or more benefits. It maintains the totality of the circumstances test that we talked about earlier, but it adds certain federal non-cash medical, housing, and food benefits in the public charge test. It establishes also new standards and heavily weighted factors. It even offers other features like a $10,000 public charge bond to cure public charge issues. And these are just some of the highlights of the proposal. The proposal includes various other features that would make the test harder to overcome. Next slide, please. So what the proposal wants to do is that it wants to add more public benefits to the public charge calculus, to the test. So the proposal wants to add the consideration of an immigrant's cash support for income maintenance, which was already there, long-term institutionalized care, already there. Non-emergency Medicaid is a new feature they want to add. Supplemental nutrition assistance programs or food stamps is another benefit they want to add. Medicare Part D, low-income subsidy, and a variety of housing assistance programs. And also, they also want to add, so they solicit input on whether they should add CHIP as one of the benefits that is counted in the public charge determination. Next slide, please. And these are the benefits that are not included in the proposal. Many of these are disaster relief programs, emergency medical assistance, CHIP, WIC, and a variety of school lunch and educational support programs or income tax credits. These are benefits that are not included in the proposal. So I just wanted to discuss a little bit about, the distinction between state and federal programs. So the rule says that, okay, in our consideration of adding benefits like SNAP or Medicaid and housing assistance, we would count those programs only if they are, either entirely or partially funded by the federal government. As we know, a state like California has a variety of programs. For example, Medi-Cal is one example that offers benefits, to both documented and undocumented immigrants, and it also offers, emergency services. So any healthcare program that is paid, in partnership between the state and federal government would fall within the Medicaid consideration, except for emergency services. And for example, any benefit that it's paid completely by the state of California or by a county or other municipality would not count towards a public charge determination, so long as it's not cash aid or long-term institutionalized care. Next slide, please. The proposal seems to categorize certain kinds of benefits. One of the categories of benefits is monetizable benefits. These include cash assistance for income maintenance, which is already included in the public charge determination. And those programs are like SSI, CalWORKS, CAPI, which is cash assistance programs for immigrants here in California, and also non-cash benefits like CalFresh, and a variety of housing programs. And generally, the proposal says, we will count the use of these benefits against you as a negative factor if you received any of these benefits for a 12-month consecutive period, and the receipt of that benefit was equal to or greater than 15% of the federal poverty level for one person. In other words, if the benefit amounts to about $1,821 in a 12-month consecutive period, then it will be counted against the applicant as a negative factor. Next slide, please. The proposal also categorizes some of the benefits as non-monetizable benefits, and this is how they contemplate the consideration of these benefits in the public charge test. So, for example, Medi-Cal, which is Medicaid, it would be counted, except for emergency services and school-based Medi-Cal for children, and except for any Medi-Cal programs that are paid entirely by the state of California. Long-term care is also monetizable, non-monetizable benefit, Medicare Part D, and subsidized housing. And the way they contemplate counting these benefits against an applicant is if these benefits are received for more than a 12-month cumulative period during a 36-month period. In other words, if an individual receives these benefits for more than 12 months, cumulatively over any 36-month period, then it would be counted against them as a negative factor. Or another way it would be counted against them is if they received a monetizable benefit and a non-monetizable benefit for over 9 months within a 36-month period. And each benefit will be counted separately. So for example, if an individual receives 2 different benefits for 6 months, then each counts as 12 months. Then the receipt will be counted as receiving benefits for a 12 months total. Next slide, please. So this is another view of some of the excluded benefits for some of you that might not be very chart oriented. So again, anything not listed in the box that has all the included benefits are not included in this proposal. And this is just another summary of those benefits that we discussed. Next slide, please. Another attempt from this proposed rule is that it seeks to kind of provide more guidance or definitions to some of the relevant factors that right now are undefined, like the age and the health and the family and financial resources. So for example, for age, it proposes to have, the consideration of negative versus positive, if an individual is, for example, too young, for example, being too young, which is under 18, would be perceived as a negative factor. Being too old, 61 or older to work, would be perceived as a negative factor. Health, if the applicant has physical or mental health condition that could affect ability to work or attend school or require expensive care, that would be viewed in a negative light as well. Household size and number of dependents will also be considered and further scrutinized. Financial resources, so if the applicant is earning 125% or lower of the federal poverty level, that would be perceived as a negative factor. Also, if the immigrant has received or applied for fee waivers for immigration benefits, that will also be counted as a negative factor. And they will also want to scrutinize further an applicant's English proficiency and skills. Next slide, please. And also, the proposal creates another category of negative factors, which they call the heavily weighted factors. So any of these factors present in an applicant's case will have more negative weight than any of the other factors we discussed in the previous slide. Some of these include health conditions that require extensive treatment, unless the applicant has access to its private health insurance to pay for it. Receipt of the listed benefits within the last 36 months of his or her application for a green card or entry will be counted as heavily negative factor against him or her. If the individual is uninsured and without prospect of obtaining private insurance or paying for care, if the individual has previously been determined to be a public charge, and one of the heavily weighted factors that's a positive factor would be if the applicant's income or resources are above 250% of the federal poverty level, which means that the individual would need to earn more than $62,000 in their household for a family of 4 in order for his or her income to be viewed as a heavily positive factor. Next slide, please. So this proposal would not be retroactive. So if it goes into effect, tomorrow, any benefits received, today would not be counted. They would only be counted if you continue to receive those benefits since the day of the rules publication. And even if the rule, sorry, let me repeat that. If the rule goes into effect today, there would be a 60-day period from the rules implementation, and from the rules implementation until the clock starts ticking for the use of benefits to count against you. So, for example, if I'm receiving benefits today and the rule goes into effect, tomorrow, I have 60 days until my use of benefits will be counted as against me. Next slide, please. So in terms of timeline, we had the notice for proposed rule published on the Federal Register October 10th, and that started the 60-day comment period, which closes on December 10th. And after the comment period closes, Department of Homeland Security has to review all of the comments, and they must address all the individual and unique comments in the preamble to the rule that they officially publish eventually. But what can happen is that after the comment period closes, the agency can take, its time to draft a new rule and publish a new rule, or publish the same rule, or it can just decide not to publish anything at all. Next slide, please. So what does this really mean for our communities? Well, it really forces immigrants to make the impossible choice between meeting basic needs and keeping their families together in the country. It also strengthens existing attempts to erode ACA and social safety net resources and efforts, and it makes certain applicants more vulnerable to refusal on public charge grounds, and specifically children, the aged, unemployed, retired persons, disabled, or those who have certain health conditions. And overall, it really impacts, working class households with limited resources and assets. And one of the things that, one of the damages that this proposal will do, and it has already been creating, is a chilling effect on mixed immigration status communities. We know, and history has taught us, that any restrictions or negative consequences, on the use of public benefits, whether it's for an individual seeking an immigration benefit or, from their U.S. citizen children, really chills the participation of that household in programs for which members in their household are eligible for. So we've seen already that some families have been either terminating some of their benefits, some of them are underutilizing them, and others, use them and wonder if the use will have any negative consequence in the future, or if it would impact their immigration candidacy. Next slide. So how do we fight back? So there are various methods of doing that, but probably the most effective one in the meantime would be taking advantage of the public comment period. Next slide. So we have the community and the public has until December 10th to flood Department of Homeland Security with comments. And in these comments, they can provide stories, research and data, and arguments about the impact, the negative impact that this proposal will have in our communities. One of the other ways of fighting back is avoiding panic and misinformation amongst impacted communities. Just to cite one example, because we know of the tremendous confusion that these proposals create, and add on to the existing policies already is that CRLAF has been working with residents and trusted messengers and even with the media to be able to provide accurate and verifiable information. And when we don't know something, we try to reach out to an organization that can help us answer those questions. And also, our national partners, nationwide partners from the California Protecting Immigrant Families campaign, and also the California chapter of it has been working proactively to gather resources, toolkits, and trainings on what the actual status of the public charge policy and doctrine is, and some of the proposed changes and how those proposals will have human and monetary impacts in our communities. And also, we encourage individuals who do engage with elected officials to educate them about the issue and to make the resources available to them so that they can be enabled to participate in the public comment submission or to lead uniform oppositions to this cruel rule proposal. Next slide, please. And why does public comment, matter? Well, it matters because it's the best and the most direct opportunity for the general public to weigh in on the proposed regulation. After the comments are submitted, the agencies are required by law to consider every unique comment and to justify its actions if they decide to officially publish either this version of the rule or a different version. Any concerns also raised in the comments that are not addressed in the final publication of the rule provide an opportunity for litigation partners to challenge the regulation in court. And also, the more comments we have and the more substantive comments we have and the more unique comments we have, also can delay the rulemaking process. Next slide, please. And really, people who have the ability to comment are, pretty much anyone. It can be impacted individuals, for example, it can be immigrant households, it can be community members, it can be partner organizations, it can be agencies, it can be individuals, it can be a variety of interested groups. And there are also options of submitting comments anonymously. And if somebody is going to submit anonymously, then we recommend that either a friend or a community worker at a trusted organization submit the comment on their behalf rather than anonymously. And the next slides will show how, some template language that can be used to submit comments for another individual. Next slide, please. So the requirements for submitting a comment online are you need the first name and last name of the person submitting the comment, the zip code, and email address. And there are two ways of submitting, two options for submitting a public comment online. One of them, can be by going directly to the Federal Register's Federal Comment Portal, which we have the link here on the page. And this page has an upload feature. So we're going to go to the federal portal. So in here, you can insert your comment. There is a 5,000 characters limit. And you also have the option of underneath the comment box of adding, an attachment. And these attachments can be a variety of things. For example, it can be a data brief. It can be research. Either research coming from, academic institutions or from your individual organization, anything that you want to be considered in the evaluation of this proposal from the agency. If you are going to include attachments, we recommend that your comment directly cites to and even quotes whatever you are referencing. That way, we increase the chances of having your analysis and your data points included and accepted by the Federal Register as an official comment. and then you can continue and submit it that way through the Federal Register. Another option that you have is using a microsite. For example, the Protecting Immigrants Family Campaign created a microsite, and other organizations, who can also speak to the issue, have created one as well. And basically, what it is, it's a portal where you can go in. So we're at the web page already, and when you can submit your comment there, and then the microsite will deliver that to the Federal Register. And again, in order for you to submit the comment, you'll need the same thing. You'll need a first name, a last name, zip code, and email address. So if we scroll down to, on the page, there's going to be a comment portal already here to the right of the screen. And right there, we have a PIF created a template comment already that can be used, and it can be customized and personalized to whatever situation that the person comment wants to highlight. And if you're going to be using this template, PIF recommends that you at least make 30% of the overall comment unique. Otherwise, when this comment gets submitted, if everybody just submits that same comment, this software recording and receiving all of the public comments at the federal agency will count that as one comment. So as a rule of thumb, it's recommended that your comment be at least 30% unique and different from the template comment that's already there. And you can, and this is one microsite that you can use. There are a variety of other microsites, and we can make those URL links available to you after the presentation as well. Next slide, please. And then here on the PowerPoint that we're sharing, we pasted the entire template comment that's ready for your customization. And you can personalize this, you can edit it, you can reword it, whatever you think will meet your need or your constituents' need, and that expresses whatever they want to comment. Next slide. For those of you who, a lot of you will be submitting comments, and your residents will be submitting comments too, or your community partners or individuals you work with. And it is totally understandable and valid for them to have concerns about submitting their comments using their names. So in order for you to preserve confidentiality and anonymity, this is one template version that you can use to let the Federal Register know that you are submitting this on somebody else's behalf. Next slide, please. So, and we know that these proposals create a lot of confusion, and we're fighting the consequences and negative impacts of them on different ends. So one of the things that we also wanted to talk about, was messaging to consumers. How do we talk to the community about this? Next slide, please. And perhaps the overriding piece of recommendations you can give to a household is, get an immigration consultation for you and for those members in your community who might not have a lawful immigration status. And that is because we want to make sure that each household is empowered to make their own decisions. We want them to know, okay, is public charge even going to apply to me anytime soon? And we want them to really know the full extent of their immigration benefit candidacy so that they can make the best decisions for their household. And so that they can understand the current doctrine as it applies, and so they can understand and differentiate between verifiable and non-verifiable information. Because individuals and households in our communities need to make these decisions at least once a year. And that's every redetermination period. So for households receiving benefits like Medi-Cal or other kinds of public benefits, they face this question, regularly in their lives. And also remember, public charge only applies when an individual is applying for a benefit, such as a green card, or for a benefit to enter lawfully into the United States. Next slide, please. And also, for individuals who are currently receiving one of the benefits that is either listed in the current public charge doctrine or in the proposal, there's no immediate disadvantage to terminating those benefits. There really isn't. And every case is different, but it's something that we need to understand, is that disenrolling now, terminating, underutilizing benefits, or not enrolling in one that you're eligible for is not going to bring you an immediate benefit. And using healthcare and their work support programs that they are eligible for and nutrition benefits do increase the chances of a person to lead healthier lives and to have better health outcomes, and increases their chances of not being primarily dependent in the government. So again, and if you have, and I can't say this message enough, if you or your residents or partners you work with have questions about whether they're eligible for an immigration benefit or for some kind of remedy, they need to consult an experienced immigration attorney or an Office of Legal Access Program accredited representative. Next slide, please. So these links here are links to the Protecting Immigrant Families campaign, the page that we were just in. And if we can just go back to it really quickly, I just want to show you that there's a resources tab on there that you can click on, and that tab has a variety of information. It has things from like fact sheets. It even has a standard PowerPoint that you can use, that has great visuals. It has some reports that were created by research institutes and also by other foundations. So and you even have access to comments, letters for your organization, and a variety of resources there. And there's also a link for you to submit specific questions that you might have to our experts at CLASP and NILC. Okay, can we go back to the PowerPoint? And of course, the resources there on that web page are not all the resources that are out there, but they are, the resources that have been published to the state that are in many cases relevant or that discuss directly the impacts of this proposal. But I also want to extend an invitation to your organization, because I know that, all of us on this webinar come from many diverse backgrounds, and something that we have access to, as individual orgs or entities is certain data. Like we know whom we serve, and we know what kind of impacts this is going to have on our community. So just to cite one example, something that we're doing here at the regional level is we have reached out to service providers so that they can document, the data, because they know how many, working class households they serve. They know that they serve primarily, mixed immigration status households. And others also know, what would be the fiscal impact to their individual organization. Another thing that we did is we reached out to a local policy institute, and we requested that they produce a data brief, a snapshot of the San Joaquin Valley. And that's just to kind of gather what information and research is already out there to make it more Central Valley specific, so that we have something, number one, that we can upload on the public comment, but also so that we can have something tangible to show other partners and even some elected officials when we're educating them about the negative consequences of this proposal. So, and now I think we're going to transition on to questions. So if you have any questions or anything that you've been submitting to your comment box, Kirti, I'll yield the floor to you.
Thank you so much, Eduardo. I really appreciate that thorough overview. As Eduardo just mentioned, please do submit any questions or comments that you have through the questions feature. We'll get through as many as we can today, and then we're happy to follow up with folks afterwards as well. So Eduardo, I have some kind of technical questions, some questions about the comment process, and then some broader ones as well. But I might just start really quickly with some technical ones. Someone was asking that they were just notified that a DPSS worker was requested to provide a sponsor's name, and they were wondering if that's something that you know about as a new rule that's part of this.
They were required to submit a sponsor's name for in what context? Was it applying for benefits or?
Unfortunately, we don't have more context. Perhaps we can follow up with this person and provide information to everybody as well if it's related.
Okay.
Thank you.
Mm-hmm.
And so then the other technical oriented one was on one of your slides, you mentioned that receiving public benefits within the last 36 months would be a negative weighted factor. But then you were also talking about it not being retroactive. So can you just clarify that? If you received benefits, before this rule went into effect, within that 36-month period, it should still not be accounted. Is that correct?
Yeah. So, for example, the proposed rule says that it would be a heavily weighted factor, right? If an individual receives one of the benefits in the 3 years, immediately preceding their application, let's say for a green card. But this year look back period is not going to be 3 years up until the rule is 3 years and 60 days old. And that's because, let's say, if the rule gets published today, right? It goes into effect today, but remember, the way the proposal is written, it says that the immigration is not going to start counting your use of benefits into 60 days after the rule has been officially published, right? So up until when that rule is 3 years and 60 days old, that's when we have a full look back period for those 3 years. So for example, if the rule is already in effect and benefits are being considered, as of today, right? Then the look back period is only 1 day old because the rule is only 1 day old. Does that make sense?
Yeah, and this gets back to your point about there being no advantage to disenrolling from benefits at this time. So I appreciate that.
Correct. Thank you.
So maybe looking at the comment period a little bit, we had some questions around kind of process of submitting comments. So some around, for instance, can comments be submitted in a language other than English?
Yeah, so that's a good question. And it has to, if it's submitted in a language other than English, it needs to be translated. Mm-hmm. So it's totally fine if you want to submit the comment in Spanish, or that's one example, right? Let's say I have a resident who wants to submit a comment in Spanish. It's totally fine for you to type it out in Spanish, but also just make it clear within the comment portal that this was translated by somebody into English, and that the person making the translation, certifies that he or she is competent to translate from the Spanish to English language. And there are some, and we'll share this out, there has been one organization who kind of took inventory of the most common languages that are spoken by some of our Asian American community members. And they have this feature where you can type it in and it will kind of automatically translate it for you. So we can go ahead and maybe gather some of those probably common materials for non-English writers so that we can share with partners.
Absolutely. Thank you. And so along those lines, I know we have many organizations that have been working with us for a while on this issue through a variety of coalitions. So if an organization has already perhaps signed on to another statewide organization's letter, could they or should they still send in their own letter?
As an organization? So let's see. So yeah, I can double check that. But I think the comment will be submitted. For example, if the comment, that they signed on to, was unique enough to constitute its own comment, right? And if it was submitted as a coalition, then it's the coalition submitting the comment. And then if that same organization that signed on to it wants to submit a separate one, I think in order for them to increase their chances of having their comment valid would be, to submit it not as a coalition member, but to submit it as an individual organization, and to have that comment be unique enough so that it will be counted as its own unique comment.
Can you share some strategies for making your comment be considered unique?
Yeah, so when we talk about uniqueness, so if you're going to be copying and pasting a template, right, like the one we shared from PIF, try to at least have 30% of it, be, personalized and customized to whatever your organization is or to whoever you are as a person, right? And then if you're submitting it on your own and making it, in your own words, then that's another unique comment. But what's going to happen is when the agency receives these comments, they have this software that kind of detects, okay, this is the same comment, right? And that software will kind of detect the copy and paste comments. And then after that, sorting, they're going to look kind of like at substance, and they're going to address and categorize comments differently. So I guess what I'm trying to say is, for example, in order to increase your chances of making it more unique, you can draw from your personal expertise. For example, if you are a professional in a certain discipline, cite to that, show that, show your expertise, show how this comment is coming from you and what you perceive the impact will be and what your position is.
That's great. And so, Eduardo, I know that CRLAF, in your work, you're doing these kind of presentations with a variety of different audiences, really trying to help get the word out and give people the information that they need to make decisions about their own families. I also know that you're working with various institutions, whether local hospitals or state and federal legislators. Could you share a little bit more about what CRLAF is doing, and in particular how such, whether it's government institutions or healthcare agencies or otherwise, like how they can help be allies in this effort to fight the rule?
Yeah, so some of our work is, working directly with the California chapter of the Protecting Immigrant Families campaign, and they have like a legislative working group, and they have various work groups that are really helping and creating an infrastructure of resources that would facilitate and enable organizations and individuals to comment and to understand these proposals. But something that we're doing here at the local level is we're trying to target those messengers, like who are those individuals who are the regular outlets of information. And those individuals are, for example, healthcare enrollers, right? We partner with a local federally qualified health center to train their enrollment staff on these are the proposals. This is the status of the doctrine now. This is where people can go to get an immigration consultation. And if you have any questions about the immigration, public benefits, crossover issues, you can consult great resources like the ones NILC has provided, or you can reach out to us for more case-specific questions. And that's because the enrollers are the ones who are really, being kind of like the first point of contact when it comes to, federal changes, state level changes, and how it impacts eligibility for benefits. So we try to target them. Another group that we try to target are, community organizers here in the region who, might not be exposed to public charge or immigration healthcare or public benefits crossover issues, but they are trusted messengers in the community. So we work with them as well, with a variety of community organizers from faith-based institutions and also from other nonprofit sectors. And another thing that we've tried to do is also invite healthcare providers to document, what the impact would be, or at least document what's the profile of the clients they serve, and acknowledge that they primarily serve or sometimes serve at least one mixed immigration status household. And what do they project would be the fiscal impacts? I recommend that if organizations have close partnerships with healthcare providers, local ones, that they encourage them to submit a brief or to publish a brief, a data brief. And if they don't want to submit it themselves, maybe you can submit it, as an attachment. And also another thing that we're doing is that there are some health related or healthcare related resource fairs coming up here in the region, especially targeting open enrollment season. So we got a spot to present at those as well, because that's going to be a place where a lot of individuals are going to be seeking help, either for enrollment services or just for information.
That's fantastic. Thank you for sharing that. And so we just have a few more minutes here, and I really like the way that you just kind of shared all that variety of information. Do you have any sort of last advice or parting words for any of our partners on the line who might still be unsure of whether they want to submit comments, or if it's an issue that really directly impacts their communities? And perhaps I also just hear from a lot of our partners, rightfully, that they aren't as involved maybe with immigration policy, or aren't legal experts themselves, and just are a little bit worried about spreading misinformation, and just recognizing the amount of panic or concern that is rightfully out there amongst families. What kind of advice could you share for an organization that might want to partner with a group that does provide these services or has that expertise in-house?
Yeah, so I think one of the ways that maybe we can frame this is that this proposal didn't just fall out of nowhere, right? There's a lot of context and history from which this proposal comes from. And bottom line, it really targets low-income working households. It targets their candidacy to be able to be fully lawfully incorporated into the United States. And we've seen the chilling effect. We've seen the impact that it's going to have directly on the applicants themselves. But there's going to be a multiplier effect where the children in these households are really going to be affected. So I guess my recommendation is, if an organization does not want to send a comment and it's their position not to submit one, then maybe they can offer, their perspective, to another partner, and that partner can submit it, citing to that perspective or that document. If they want to submit public comments directly, like I mentioned earlier, you can publish something on your website, whether it's a data brief or something that individuals can use to provide more substance to their public comment. And also, and I invite you to think of it this way, even when the period of comment closes, the work is going to continue, because we're going to have to demystify the actual policy and rules versus the proposals. So this thing already is going to have a long-term consequence. So even if you approach an organization and they don't want to sign on, don't view that as the end of the potential partnership. View that as in, okay, you might not sign on to this already, but I look forward to working you post-comment period, where we're going to have to do a lot of the work on the ground.
Absolutely. I really want to underscore that the comment period is just one part of this strategy, and as everything Eduardo has outlined, we're seeing impact on the ground already, and we will see the impact for a while to come. So I really do value all the partnerships that we have. I want to thank Eduardo for sharing all this knowledge today. And for those of you that are on the phone, thank you so much for being here. Thank you for your questions and your amazing partnership. As I share, this will be recorded and shared back with all of you as a resource. We hope you'll share it with your partners and anyone you work closely with. And if you have any follow-up questions, our contact information is on the slides, and you could reach out to either of us for further clarification and information. So I think we're just over noon right now, so I want to respect everyone's time and just thank you all for joining us today, and we will talk again soon.
Thank you, everyone.